Hello, so this video is on how COVID should have you thinking about estate planning. With news of whole countries being locked down, disease spreading at an exponential rate, and more serious measures are being taken on a daily basis to combat COVID-19. People are frantically thinking of a worst-case scenario and what to do if they catch this highly contagious and destructive bug. Um, Estate planning lawyers across the country are being contacted to hurry and help other people get their affairs in order now. If you're worried about what the coronavirus may mean to you, consider these key questions. So, do you have an estate planning documents in place, and if so, what are they? The cornerstone of most estate plan is a will or a trust. A will is a document that explains that what happens to your property after you die. It also nominates a guardian for your minor child if both parents are deceased and names an executor you trust to carry out your final wishes. A trust provides more flexibility and can explain how to manage your property at the time of your death, as well as if you become incapacitated. You can leave detailed instructions in your trust for any property you transfer to it. Using a trust is an effective way to avoid probate, which is now more important than ever since many courthouses are closing down, and even typical probate cause cases often take longer than a year, during which time your loved ones likely won't have access to your assets. Won't have access to your assets. Sorry, if you contract COVID-19, you may be too ill or just plain tired to communicate your health preferences or manage your money. So, putting a durable power of attorney and healthcare provider of attorney in place can provide you with peace of mind and having a trusted person look after you and your affairs if you become ill. So, another question is, are you in a serious but unmarried relationship? If you are married or in a legally recognized civil union, the law automatically provides certain protections for you. Your spouse is typically guaranteed a portion of your estate through the laws of intestacy, and can usually make medical decisions for you even if you don't have anything written down. However, many people today are deciding not to get married, even if they are in a serious relationship. If you are unmarried, your significant other may have no legal rights to handle your financial affairs unless they are also on the account. Visit you in the hospital, make key medical decisions for you, or stand to inherit anything from you if the worst occurs. Fortunately, you can provide your romantic interest and give them these powers, but you need to do so now and in writing. For example, you can designate your partner as your durable power of attorney to manage your expenses and income if you become ill. This may make the most sense if you live together. You can also make your loved ones as your healthcare agent. For some financial accounts, you can designate a person of your choice to receive the remaining balance in your account when you die without having to sign over any immediate interest in the account. Talk to an estate planning lawyer to learn the rules and arrangements that make sense for you. So another question is, can someone access your important information in case of an emergency? Seriously consider these questions. If something happened to you tomorrow, would someone be able to take on your finances? Would they know who your creditors are and be able to pay them on time? For many people, the answer is no. One person in the family may handle most of the financial responsibilities. Many of us use online banking and conduct much of our own business over the internet. However, if something happens to the person with these responsibilities, it is important that your loved ones be able to provide their basic needs. Ensure that your family has the essential information. This would include the location of your estate planning documents, emergency contact information for financial advisors, your attorney, investment advisors, and other professionals, account information for your financial accounts, the name, account numbers, and how to access and pay bills, important passwords to your device and online accounts, Another question is, do your loved ones know your values? If you become ill, do your loved ones know what type of medical treatment you would want to receive? Do they know when life-sustaining measures should be used or withheld? Preparing an advanced healthcare directive that details this information is important to prevent your loved ones from having to make difficult decisions during their time of grief. And finally, do you need estate planning advice? While COVID-19 has many of us scared, it's important that you do not panic. Doing so can lead you to make serious mistakes that can long outlast the virus, such as signing over your property to another person, making you ineligible for nursing home payment assistance, or giving too much power to an untrustworthy person. Having a frank and level-headed conversation with an estate planning attorney can help you determine your needs and start the process of protecting your health, money, and legacy in a way that honors your values. So, thanks for listening.